All rise. The Court of Appeals before the 5th District of the State of Florida is now in session. The Honorable Adrian G. Sal, presiding judge. All persons having business before this court, draw near, pay attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
All right, ladies and gentlemen, good morning to each of you. It is a privilege for us to be at Jacksonville University this morning and with the College of Law for a first, not only for Jacksonville University, but for the 5th District Court of Appeal, and that is for the 5th District to have session here in Jacksonville, Florida. As you may know, of course, effective January, the District Courts of Appeal were realigned, and the 4th Circuit, which includes Duval County, of course, was brought in to the 5th District Court of Appeal. As we begin this morning, I wanted to, if I may, just introduce my colleagues who are here with us for purposes of our work. Seated to my right and your left is Judge Harvey L.J. III. He is an esteemed colleague. He is the longest tenured of the judges this morning, and customarily he would preside over the proceedings. He has asked if I would be willing to do that, and of course I'm happy to do that this morning. Judge Jay served on the 4th Circuit Court from 2011 to 2016. He was appointed by Governor Scott to that position, and then later in 2016, I believe it was February of 2016, was appointed by Governor Scott to serve on the 1st District Court of Appeal, where he served until January. And he has a distinguished legal career prior to his service on the courts of the state of Florida, with more than 20 years as an esteemed and well-regarded trial lawyer. To my left and your right is Judge Paige Kildane. She was appointed to the 5th District Court of Appeal in January, began her service in January of this year, as I did. She served as a Palm Beach County judge since 2018, appointed by Governor Scott, until 2020, when I believe Governor DeSantis appointed her to the 15th Circuit Court for the state, and then, as I've said to you, began serving on the District Court of Appeal in January. She also has a distinguished practice both as an assistant state attorney in the past and in handling complex civil matters until her time of appointment to the courts. And so we're grateful for both of these wonderful jurists and their time with us. If I can just share with you briefly before we begin with arguments, I wanted to introduce my law clerk, Ben Wood, and he's here with us as well, and I appreciate the work and I appreciate his attendance and being with us. And thank you to all of you who are here. So that you can know, after our first case this morning, once oral arguments have concluded, we're going to take a brief recess and have a coffee reception out to the side of the hall for a few moments, and certainly you all are welcome to join that should you wish to do so. At this particular time, the first case we will handle for oral arguments is Orrin Miller versus the state of Florida. It appears as though counsel is in place for that. And so each of you counsel, as you well know, you'll have 20 minutes for oral arguments. Appellant's counsel, should you wish to reserve time for rebuttal, you can let us know that. The default, of course, is 5 minutes. But if you wish for a different time, you can let us know. With that, appellant's counsel, you're welcome to proceed.
Please report. Presiding Judge, members of the panel, Mr. Caldwell. Good morning. My name is Doc Blanchard, and I represent Orrin Miller, who is appealing a conviction for perjury in an official proceeding in Marion County, Florida. The basis of that appeal is actually threefold. The first is that the statements that he alleged to have been perjuries about were not material. The second is that they were based upon imprecise and leading questions made after he already made other statements that contradicted the statements that were alleged to be perjuries. And finally, that the basic evidence that was presented was on a crime that he was not charged with. That's the essence of the legal argument that we're
I
going
want to
to
make
make.
sure I understand this, Mr. Blanchard. I believe I just heard you say he says something early that is different than what he was charged, correct? Meaning he initially said, I've got the transcript in front of me, that the calls he believed stopped in January or February, and maybe February or March, and then he says, I can't really remember that time. I can't give you the exact time. And then later he is pinned down on the January time. Is that what you're saying? That's part of the argument.
And after having said that, the examining state attorney came in and said, well, you said it stopped in January. Well, he didn't say that. He said January or February. And he said yes to that.
Well, thank you. And I saw it. And there was nowhere in this record on this transcript before the state attorney said that where he had said the call stopped in January. Correct?
Correct.
Does that matter? I mean, is that a feature of this? The fact that it's sort of embedded in this argument, unsolicited?
I believe it is. Materiality is an element, it's a big question of law and fact that we're rules we state. I thought it was reported. And in that particular case, the gentleman had been investigated for improperly taking municipal funds. And part of the testimony, he testified when he was asked and inquired quite a bit about what he did with these funds. And the court reversed it, the Supreme Court reversed that, saying that was not material to the original charge. And this particular materiality goes along with this lack of consistency of the statement, because in the rule, the court also says that imprecise questions cannot be the basis of charge for perjury. That's a quote from Wolf. And these were very imprecise questions. When he said January, February, later, he said April. He said 4 or 5 different things. And instead of trying to say, hey, you knew when the phone call, they already had it. They already had the testimony of the other county commissioner that the phone calls didn't take place.
Well, in that feature as well, they actually confront him with those records. And I believe at one point in the transcript, he says, I don't deny making the calls.
That's correct.
So when he says, I don't deny making the calls, that's completely at odds with the fact that he purportedly, definitively said that no calls out of January, correct?
Yes, sir.
So is that enough as a matter of law for us here as a appellate court to say a JOA should have been granted based on the sufficiency of the evidence?
Well, in his great judgments, according to that belief, as well as the rule, the inconsistent statements cannot be the basis of perjury if they're made within the same proceeding. And that's his way, which I cited in the brief. And that's what I'm trying to say. If you look at the totality of what he said, he just didn't know. And he shouldn't have his mouth, but he did. There without an attorney, he gets in front of everybody. He's called in. He was elected in November of 2020. This event, this supposed complaint was made about it. County Commissioner happened in February of 2021, 4 months later. This interrogation occurred in October. And he was brought in because the complaints had nothing to do with telephone calls with Mr. Search. They had to do with alleged using his wife as a conduit to make conversation with Mr. Search. Now, it's important to note that there's no question that Mr. Miller and Mr. Search met all the time. They would go pick up donuts, pastries and stuff for the county commission meeting. And so they were meeting, they were talking. That was not the issue. And then they focused on when did these telephone calls stop. How's that material to what the telephone calls were about? Everybody, including Mr. Search and Mr. Miller, has testified in that proceeding that it had nothing to do with county commission meetings, nothing to do with county commission business. What this was an effort to get Mr. Miller to make a mistake. And he did. He did.
I've got the transcript of Mr. Blanchard, and I'm looking at page 140. And again, this is the first question, the first real question about when these calls started to stop. And he, your client, definitively says, I can't give you the exact date, time, says that serially through the course of this transcript. Is that the fact that he serially said, I can't give you the exact time? Is that enough for us to say, as a matter of law, there was insufficient evidence here occurred?
Yes, sir, because intent. How can it be intent if he says, I don't really remember? If he said, absolutely, he didn't say that. He never said that. In response to a question by the state attorney, he said yes. He stopped me.
And so the panel understands, Mr. Blanchard, that the law is at the time he made the statement, he had to intend it to be false.
That's correct. And if he intended it, he wouldn't have said all the other things. He was just absolutely a fish out of the water. And unfortunately, he didn't realize it, and he got thrown into it and hooked. And he made a mistake, agreed with the mistake, yes. He shouldn't have done it. He should have come back and he said, I really don't know. What she said, I believe 4 or 5 times. I really just don't know. Now, how could that be the basis of an intentional falsehood when he said, in addition to making a false statement, he says, I really don't know.
Is it your position, your client's position, that it was a false statement, or did he dismiss it?
It was a false statement, yes. It was a false statement in response to a leading question when he previously said something contradictory to it. In fact, you said January, he said January, February, but he said yes. He's like most Americans, you're going from a body, state attorney, you want to be cooperative, you think you've done nothing wrong, and you want to say yes, of course, yes, I've done nothing wrong, I've nothing to hide. So he agreed with the mistake. He should not have. That was an error. But if you take it in the context, as is required by Wolf and his women, in the context of the entire statement, there's no way in the world that could be a materially perjurious statement.
So when you acknowledge, if I heard you correctly, you acknowledge that it was a false statement. Are you saying it was inadvertently
Yes.
false? You're not conceding that it was knowingly false?
Well, it's a false statement. It's a false statement that we'll call after January. But he was saying that, yes, in response to a leading question by the state after he previously said January or February. If the state said, and you said they stopped in January or February, that would have been incorrect. Instead of the state following up on that and saying, why did you say that earlier? They just said it. Didn't try to develop it in any way. Then he said it later on, April, March, I really don't know. Intent. There's just absolutely materiality and intent tied together in this thing. It can't be material if it's not intentional. And it's not material.
So we understand that, again, just what I understand, not only individually, but for our panel to understand, you're saying that even with that statement, he didn't intend to deceive the questions.
By the evidence that was before the court, no.
So you're saying it was a false statement, but there is also this intent component that has to be coupled to it, has to be tethered to it. And your position on behalf of your client is he didn't intend to deceive the questions, correct?
Yes. It's sort of like, how many people really know the last time they had a phone call, whoever? They don't. But someone got the record confirmed, and you assume that they know. So you assume that they made the question, and they got the record in front of it, they know. But they didn't say it correctly after what he had said. So you just said, yes, you should not have said that. I agree. But it cannot be material, because it had nothing to do with the charge of the investigation.
I'm sorry, go ahead.
Please.
Does the sequence of when the calls were made in relationship to either meetings or letters that were received from the state attorney's office, does that not make the timing of the statements when these calls would have been made material?
It does relative to each particular county commission meeting. And that's the reason I laid that out in my brief. The calls that they're talking about, and we have the records during the record, were after the meetings, not before the meetings. That they meet personally during this period of time. The calls had nothing to do with what they could have said at the car or coming back from the donuts. If they wanted to talk about something, they could have talked about it then. It was just a tool. And the state knew that, but they focused on phone calls. Focused not on what the subject of those phone calls are, which was an alleged violation of the sunset, we still when they occurred. And when they occurred, we know from the record it stopped in July, and this interrogation happened in October. And he's trying to get the records from him. He doesn't have anything from him. He doesn't know when he goes in there that day that they're going to focus on when and where, when he had telephone conversations with this church. He assumes that the focus is going to be on this white day time of communicating with this church, because that's what the investigation is about. So I think what we have, when we look at the totality, given the right competitive and statements, if I could quote. There is further reason why the conviction for perjury cannot stand. It cannot be said with any degree of certainty by a fair reading of all of Wolf's testimony that the two challenged answers can be considered perjurious in a full concretude, in the full context of the testimony. Further, a charge of perjury may not be sustained by the device of filing a statement of the accused out of the immediate context and thus giving a meaning totally different from that which was clearly intended. That's what was done in this case.
Well, counsel, and I acknowledge both, but I guess my question, Paris versus State, are you familiar with that case, the fourth DCA case from 2023?
Yes.
And in that case, there were two perjury charges that were appealed. And looking at that entire record, essentially one was upheld and one was reversed. So if we're looking at the whole record, essentially in that case, they sort of rehabilitated and redirected the questioning. How do you square that with both and what we have here?
Well, that's a court church where statute for change reputation requires a lot more than what we're talking about.
Correct, and that's what's in here as well. So it's not there, but
We're not talking about reputation. What we're talking about is the intent. Take the context, the whole context of this long examination, you just know what it should be. I agree with that. But it didn't affect his investigation in any way. He was never charged with some kind of violation. Ever.
well, isn't the reason for that counsel that he received use immunity? Isn't that right?
They didn't need his testimony for immunity. It's use immunity. They can still charge him. Absolutely. I also believe that the case is tainted by the unfair focus on violation of sunshine law. At the trial, the vast majority of the evidence was to the day was by the two people talking about what the sunshine law was. And the fact that Mr. Miller and Mr. Sherwood informed what the sunshine law was, the meaning of the sunshine law, the procedures for the sunshine law, how to violate it, avoid violating it. That was the full text of that testimony. And it had nothing to do with when the phone calls. Nothing. I objected, I didn't know what you were limiting before him, it was denied, and so it came in. It shouldn't have come in. It unfairly tainted. It was evidence of a charge that was a charge. He wasn't charged with violation of sunshine. Mr. Search testified. He admitted the phone call, but he also said it had nothing to do with the county commission business. I asked the investigating officer if he had any personal knowledge of whether or not it was a violation of sunshine, and he said, but nonetheless, the focus of the evidence presented by the city was a violation of the sunshine, not this phone or these phones. What they got? It was not about anything that was a violation of the sunshine. And it never came up with it. Yeah. It was just weird. Just weird. After he said, I don't know, several times, and he said January or February. It's just
Counsel, you're welcome to continue. I wanted to let you know you're into your 5-minute rebuttal.
I believe, based on the evidence that was presented, it is clear that this was not an intentional perjury statement in the official proceeding, and this court should demand it back from our proceeding.
Thank you, counsel. Mr. Caldwell.
Thank you, Your Honor. Good morning. May it please the court, my Council, of course. I'm the Attorney General's office, and I represent the state of Florida in this matter. The issue of materiality is very important. Of course, the statements were material. Materiality under the
Mr.
case.
Caldwell, let's fast forward. I don't disagree. I think that the statements are material. I don't see that as an impediment. Let's talk about sufficiency. And again, for this judge's understanding, this is all about this transcript, this interview transcript, correct? That is the predicate, the basis for this perjury.
Yes, there is some supporting evidence in Commissioner Searcher's testimony, of course, but yes.
And the information said that Mr. Miller committed perjury by saying that the call stopped in January, correct?
The exact information, Your Honor, I believe, was that during his interview on October 6th,
I'll read it. He said there were no telephone conversations between him and Sumter County Commissioner Gary Search after January.
correct.
So the whole basis of this case is nothing after January, correct?
Yes, Your Honor. However, I think, with all respect to Appellant and their argument, I think they're taking a bit of a dual approach here. They're saying that the questions were not specific enough with regards to these phone calls or what they were about.
And I'm not there. I'm going to get it.
Okay, I'm sorry.
I'm not there. But I mean, the charge here, what was argued to this jury was about January. The call stopped in January.
Yes.
And if you look at the transcript, as I just referenced to Mr. Blanchard at page 140, I don't know if you have a copy of the transcript.
I have something that's not taken here, so I can't give you chapter line numbers.
Well, and his first answer, Mr. Miller's first answer questions about when these calls happened, he said after about the first 2 or 3 months, and they're talking about after the election, all phone calls had stopped, maybe 3 or 4 months. So you have him early saying January, February, possibly February, March. I can't give you the exact time and date. Did he ever get charged, Mr. Miller ever get charged for saying that the phone call stopped in February?
He was charged because he said that the call stopped in January, but then he later conflicting testimony. You don't have a transcript, but the statements were a bit more involved. When he was first asked, he said, I think they stopped.
I've got it in front of me.
Yes.
My question is specific. Was he charged with the call stopped in February?
Yes, sir, because the information says they stopped in January, therefore any calls thereafter that he denied making were perjury.
Well, I mean, that sort of begs the question, does it not? I mean, if I give you information, you lied by saying the call stopped in January. So if he said the call stopped in February, you're saying that was part of the information?
Yes, sir, because he gave several statements and they were conflicting statements. First, the February statement, the original February statement, he was asked when did they stop. He said January, February. Later, he was asked definitively when did they stop, and he said January. He was then confronted with the February 16th or 17th calls. And which was after the commissioner meeting where the sunshine violation was first raised. He was then asked about calls in March, and he said, well, I told you, I thought the call stopped in March or April. And that's when the investigator said, no, you said January. They continued to ask him about calls, how long they took, for example, the 975-second phone call in February that he stated he did not recall. And he also made conflicting statements affecting his own credibility. He said, listen, the call stopped, we didn't discuss county business at all, because we were trained on those calls before sunshine violations.
And he made a decision in March. He was asked about the March calls.
Yes, sir.
And he said, I don't deny making calls. I mean, he doesn't make comments.
No, sir, because first he unequivocally said he did not make them in January, but the focus of the investigation was not just did you make telephone calls. Anyone can make private telephone calls. The focus of the investigation, which ties into materiality, is was there a sunshine law violation? Did he discuss county business outside the view of the public?
And I hear you, Mr. Caldwell. That's not what the information says. The information says he lied, he committed perjury by saying the phone call stopped in January. I mean, that's this whole case.
Yes,
we're not here about a sunshine violation. Are we? We are.
No, perjury, that's the official proceeding in which he perjured himself.
Which I understand, thank you for that, Mr. Caldwell, but, I mean, the whole basis of this perjury claim is that he said the call stopped in January.
Yes, sir.
But then he tells us January, February, he tells us February, March, he says March, April, and then he says, I don't deny anything the March calls.
But as the court pointed out, the trial court pointed out, he actually didn't make that statement until he was specifically confronted with phone records. He made a statement that they stopped in January, but then said, what about the other calls? Maybe they stopped later. And then he expressed an inability to remember, or began to express an inability to remember.
And the trial court did point that out, thank you, Mr. Caldwell. I've had that for you. I used to be a personal injury trial court, and let's say we have an auto case. And the claim is a soft tissue injury to the neck. Auto case, plaintiff is claiming they have a neck injury. And so the defense lawyer says, before this accident that we're here about today, did you ever have a problem with your neck before? Oh, no, sir, I did not. Did you ever seek treatment for that neck? No, sir, I did not. Did you ever have any other trauma to your neck? No, sir, I did not. And a break is taken, and it turns out the defense lawyer has records saying there was a previous accident and previous treatment and previous complaints. So I'm not sure I would have done it, but let's say this defense attorney comes back in and says, just want to tell you, I've got records showing that you did have that pain and you did have a previous accident and you did seek care treatment. And the plaintiff goes, I don't deny anything. Is that true?
If you make your own questions, if he initially states that no, I never had anything done on my neck, to take a break, and then come back and say, yes, you did, and he then admits it and recants, if there's a specific recantation, then no, it's not perjury, but there was never a specific recantation here. There's a general, I'm not sure when the call stopped. He never said absolutely.
But that's a valid answer.
I'm sorry?
That's a valid answer.
Yes, I'm
And I will back up with you just
Sure.
a minute, if I may. This is a 71-year-old gentleman.
Yes, right.
Moved down to Florida from Illinois 10 years or so prior to being elected to the commission there, is that right?
Yes, sir.
He wanted to come down after retirement, play golf 3 days a week, etc., right?
Play golf, pretty good.
Right. So in his first 71 years, he has no criminal record that I'm aware of in the record. No.
Correct.
So, and I think Judge Jay is certainly referencing the point, but this all occurred in one proceeding.
Yes, sir.
Is he not allowed to acknowledge or offer whatever clarification he can in subsequent answers when presented with records that may demonstrate a prior answer was not factually accurate?
He is, one can abandon crimes, including perjury, but there has to be a specific recantation before the proceeding is over. That didn't happen here. It was really more of an expression of amnesia.
Go ahead, sir.
Oh, I was going to say, he did not specifically admit or deny the calls. He said, you've got the record. I'm not denying them, and he didn't admit them either.
But he repeatedly expresses uncertainty. And in fact, on page 149 of the transcript says, I promise you we had calls.
Correct.
And so he got a relatively unsophisticated citizen, as far as unsophisticated in dealing with interviews with the elected state attorney in the room, one of his chief investigators in the room, is equivocal in his comments, is being asked questions. The timeline softened in the beginning about January, February, then it's 3 to 4 months, that extends. Questions are walking through March, then they're asking about a June letter and a very quick phone call in June. Ultimately that takes place. But Section 837.02 requires the state of Florida to prove that when he made the statements, and you correct me if I'm wrong, if I misperceive the statute, that he actually believed his statement was false.
Correct.
And is that not a fairly high burden when the transcript of the interview is replete with, I don't recall, acknowledging phone calls that occurred. I promise you we had phone calls, but ultimately denying that any substance of those phone calls would have violated the subject.
Your Honor, if the only evidence they had was just that transcript, then perhaps that would be the case, but there was more. Recall Commissioner Search did testify that he and appellant had private phone calls via their private cell phones, not their commission-issued cell phones, up through June or July. The state also introduced a copy of the subpoenaed phone records, which showed the calls starting in November going through June. They also introduced into evidence a copy of the commissioner meetings. And
But careful, he didn't deny the calls. He said the record is the records. So at that point, what does that really add? That doesn't change anything. It just goes more to him saying, okay, if that's what it is, that's what it is.
But in essence, he did not specifically admit to making a call either. He did not recant and say, you know what, you guys are right. I'm looking at the records, you're right. I had phone calls in March. I had phone calls going all the way to June. He said, I don't remember what happened. I don't remember any phone calls, but I know we didn't discuss county business. So how can you not remember the phone calls, and how can you not you're saying how not remember or remember that there was no county business discussed. The timing in this case is very important. When you cross-reference.
What he did, Mr. Caldwell, I know you don't have the transcript, it's 148, talking about the calls, and he said, this is, quote, I'm not saying I didn't make it. I mean, how is that not a game over event? I mean, he's saying, I'm not saying I didn't make that. So it was a strategic play, perhaps, by the state attorney and the investigator to confront him with these records. Whether they should have done that in the context of this, I'm not here to second guess, but they did. And in response to that, he's saying, I'm not saying I didn't make that. So isn't it a concession that he made? I just don't know how that is not a correction of what he had previously said. Help me understand how that's not the game.
I like it's not a game changer, Your Honor, because it's not definitive enough to be a specific recantation. It is very general, and also whether or not the question of intent is, did he know the statement to be false? That's a credibility question for the jury. That's where, once again, you have to look at the timing, and the timing of when he started to say he didn't know. I already mentioned what the trial court said, how he mentioned the amnesia did not start to come into play until he was confronted at a specific time. But when you look at the calls, roughly 42 calls between Commissioner Search and appellant occurred within 1 or 2 days of the county meeting out of the 71 calls. That's something the jury could consider. The jury can consider his own credibility to determine whether or not they believe he knew about those calls or not. So to simply give well, I'm not going to deny it, but he never admitted it either. He still never admitted to taking those calls, even when confronted with them.
What about Judge Tilbane's point, and this is on page 173 of the record. You've got a record that says they were made, so I mean a record's a record. I mean, again, isn't he saying whatever those records say, the record says? I mean, isn't that a recantation of what the state claims was an earlier perjurious statement?
I don't remember, Your Honor, because I believe it was either shortly after that they took a break and came back. He was still given the chance to recant completely. They asked him, when did these calls stop? The whole point was to determine if you're investigating whether or not sometime law violations occurred. The first step one, was to determine if calls were made. They had phone numbers, they know calls were made. They had Commissioner Search's testimony from a prior review. They didn't call were made. Initially saying, the appellant says, no, I never did any calls past January, and now he's not specifically recanting, he's equivocating. He's saying, well, you've got the records, I'm not going to.
Actually, what he first says, I know you know this, what he first says is January, February,
Yes.
February, March, but I really can't do today. I mean, that's what he first said. And that's a big deal to this judge, too. And then he's led into saying January only, and then he says the record's a record, and then he says, I don't deny making the calls. Again, before the Supreme Court tells us we're to look at this in the full context, and looking at it in the full context, how can we divine from this man committed murder? I want to hear you on that. I mean, if we look at this whole transcript of what transpired.
Yes, sir, and really I would be referring back to some arguments that it was not just his testimony again. I don't want to repeat myself again. We've got the transcripts of the telephone call. We have the dates cross-referenced with the commissioner's meetings. You also have an inconsistent statement by the appellant himself. He said we would not discuss any commission business because we had our training before the election and then shortly after. So we made no calls. But then later he said we wouldn't have discussed it because we knew that in January, the meeting group will pay. It's a sunshine violation. Both statements can't be true. Either they never made phone calls, never discussed county business because they were trained not to do it, so the phone calls there never would have been a violation, or they knew that they need to stop in February. He's made two inconsistent statements, which bear on his credibility, which also bears on whether or not is he really recanting from this statement? Is he really saying, maybe yes, maybe no? And this probably has very to convince Your Honor on the timeline. I just want to point out that it was actually first said January, February. He then locked down the renters in January. He was confronted then in February, and then he said that was the point where he said March or April when they gave the specific 9 or 75-second call.
And Ms. Caldwell, you're a fine lawyer, and also the court, and we appreciate that. And I'm sorry you don't have this transcript in front of you, but I don't read the transcript that way. His initial response says, after our letter, this call stopped in 2 to 3 months, or they may have stopped in 3 to 4 months. Well, if we do the simple math there, we have January, February, March, and then he says, I really can't tell you when it stopped. That is his first answer, and then later he volunteers, you're right, January, February, and then he's asked, well, you said January. Well, he really hadn't said January. Let me ask you about that, because I think it may be important, but maybe not. Let's call it. At the time he is asked, you said January. He had not said January. Is that a big deal for us? I mean, it was just simply not the case.
No, Your Honor, simply because, again, since the technique of the interrogation was not brought up an issue, I did not say citing a case law about what police and law enforcement may do in an interview. Police may lie. They will frequently tell someone, listen, your buddy confessed to everything, so why don't you come clean? So whether they were locking him down in January, whether that was true or false, that is a method to see if someone is lying. They're being unequivocal in the beginning.
Well, the confessing co-defendant is a starkly different situation than here.
Yes.
Now, when saying you've already said X, and it's questionable whether or not he in fact said that. If the appellant here, Mr. Miller, just simply acknowledges or affirms what is described in his prior statement, that's a very different situation. You would agree with that, would you not?
I agree with it, Your Honor, but it's still an admission. He still could have corrected it. He still could have said, no, I already told you in January and February. He did not. He said, yes.
So can a failure to correct what you just described, he should have corrected, and I don't remember if it was the chief investigator or the state attorney at that point, but can the failure to correct then form in part or in whole a basis for perjury?
I would argue, yes, sir. You give one statement, and then you then give another. You would then ask something, and you affirm a different statement, something that's contrary to your earlier statement, that could be perjury and official proceeding. And I expect that's not the only discrepancy in this case. A call went well beyond January or February. If there had been one call in February, I could understand the court say, okay, hold on, counsel. But again, he said the call stopped in January, February, and he later amended that answer yet again to March or April, and that's what known for. The investigator, neither the investigator nor the state attorney said, well, was it March or April? That was out.
And it goes, problematically, there's calls in June. He gets a letter, it's a pretty quick call.
Yes, the last court call that I know was, the subpoena was only from November through June, so there were calls throughout that entire time. So I can't definitively say when the last call ever, but it's just the last call that's listed in the records. So, Your Honors, do you have any further questions for me? You wish to address? Very well. Thank you, Your Honor, for your time, and state ask that you affirm the judgment sentences below in all respects. And I will rest on my brief. Thank you.
Thank you, sir, very much. All right, Mr. Blanchard, if you wish to have a rebuttal, you have 4 minutes, 30 seconds.
Be very short, Your Honor. Quite simply, the evidence is sufficient to show Mr. Miller made a willful mistake under oath with the intent that he relied on. He tried to correct himself. If he intended it, he wouldn't have admitted calls up until January, because that would have been a crime if they had involved sunshine law violation, as well as December. He admitted this. And he said January, February, and he said April, and he said yes when the state attorney said, well, you said it, and stopped. That was not true. This case should be reversed or amended.
All right, thank you both very much. At this juncture, we will take a recess until 11 o'clock.